one of the members of appropriations as well.
We're live.
Thank you, that you're fighting for them. All right, good morning. This is Senate Judiciary. This is April 20th, 2023. Our first bill we're taking up today is H45, an act relating to abusive litigation filed against survivors of domestic abuse, violence, or sexual assault.
And there is a new version posted,
There
but
is.
I haven't got copies yet.
Okay, there's a new version posted that we don't have copies of yet. So, but we do have some witnesses. Laura Early, project director with Vermont Legal Aid. Laura, she's on Zoom, so we're gonna invite her in to give us some testimony on H45.
Good morning.
Welcome.
Thank you.
We've got a lot of guests in the room, so I think I'm gonna introduce Senator Baruch, who's not here yet, from Chittenden. Chittenden Central.
Nader Hashim, Wyndham County.
Dick Sears, Bennington County,
Tanya
and
Vyhovsky,
parts of Wyndham County.
Tanya Vyhovsky, Chittenden Central.
Bob Norris, Franklin County District.
Great. Laura, go ahead, please.
Good morning, Mr. Chair and members of the committee. Thank you for the invitation to speak about my experience assisting survivors who are dealing with abusive litigation. I am the director. I'm sorry?
Can you get a little closer to the microphone, please?
Sure. Let me just increase the volume a little bit. And move in closer. Is that better?
That's better. Thank you.
Sorry about that. My name is Laura Byerly. I am the director of the Victims' Rights Project at Vermont Legal Aid. I have more than 16 years of experience representing survivors of domestic and sexual violence in a variety of legal cases. It is important to remember that abusive litigation is first and foremost abuse. It is litigation that seeks to control and intimidate, not to address a legitimate legal need. The abuser succeeds just by filing. They have won before I enter an appearance, file a response, or walk into the courtroom. Their goal is not to win a legal argument. That is a bonus if it happens. In my experience, the abuser seeks to force the survivor to respond, to render meaningless the no contact provisions the survivor fought for in the relief from abuse process, drain their finances to pay for representation, force them to stay stuck, reliving their trauma as they prepare, and then add to that trauma by confronting them face-to-face at a hearing. I see abusive litigation in frivolous small claims suits, claims for money brought after a divorce order an abuser didn't like, suits for defamation for daring to speak to a probation officer or the parole or the police. But most commonly, the most common forum for abusive litigation is the family division. This is because family court orders are, by design, the most easily modifiable, especially in cases involving minor children. There are very limited resources to help survivors dealing with family law cases. Abusive litigation strains those resources beyond the breaking point and quickly scares away those volunteers brave enough to take on a pro bono or low bono family law case. Often when I take on an abusive litigation case, I have to make preparations for receiving some of that abuse myself. While I will never claim to have endured even the smallest amount of the abuse my clients have faced, abusers don't like it when I cut them off from their victim, when I dare to take away some of their power and their control. They're quick to share some of their abuse with me. They hurl insults, try to get me to create a conflict by soliciting advice, threaten professional responsibility complaints, occasionally stoop to personal attacks and threats of physical harm. The distasteful communications I receive are just a small reflection of the abuse that my clients endure and aren't offered as a comparison. Dealing with an abuser is just part of responding to an abusive litigation case. But in Vermont, we rely on pro bono and low bono attorneys to help close the justice gap for people seeking family law assistance and who can't afford to pay for a lawyer. Unfortunately, it's easy to see why a volunteer wouldn't want to take on this challenge and why abusive litigation can scare away those volunteers who are willing to try. These cases require far more resources than the typical case. The discovery process is often weaponized and requires double the time to respond. In the hours used to handle only one abusive litigation case, I could have taken 10 relief from abuse petitions, a dozen rent escrow cases, or fought to keep 6 housing vouchers. I could even have taken a case from the trial level all the way up to the Supreme Court and back and still had a week's left of work hours to go. These cases drain limited resources and take up precious court time for no legitimate legal need. I have actively looked for cases involving abusive litigation in an attempt to find a way to stop this from happening again and again. What I've found is that there are very few tools available to limit the abuse. Sanctions are only available currently in the most extreme situations and after an overwhelming number of motions have been litigated and the harm has already been done. Abusers are using our court system, a place where survivors are supposed to be able to obtain justice, to perpetrate abuse and continue control. In the process, they overburden our judicial system, drain our limited resources, delegitimize the courts in the eyes of survivors, and there is no way to quantify the personal toll these cases take on survivors and their children. Survivors and those who help them need better tools to address this problem. And I thank you for your time today for considering this important legislation.
How prevalent is abusive litigation?
Unfortunately, we don't keep statistics specifically on what is abusive litigation, but I have routinely seen dozens of these cases over the past few years. We just don't have the power to take them all on, so we tend to give advice and we just categorize them as family court cases. So there's no real hard numbers on what's an abusive case, but listening to the survivors who testified previously, I can say that I have heard similar stories dozens of times, and that it isn't uncommon to see 45 to 50 motions filed post-judgment in family court by abusive litigators.
Thank you. Senator,
I was just, to your question, I was just going to say, I've seen it a few times at my firm, just the abuse of litigation in family cases. So.
do we have a shortage of family lawyers?
I
And
think
does
we
that
might.
contribute to the problem?
I think we might. Family division is one of the more common places where people seek justice or seek remedies from the courts. It's where more people interact with our court system. And these cases are often messy and complicated and not something that people are willing to take on because of that.
I had a constituent.
I'm sorry.
I was at a constituent who was concerned about his grandchildren and trying to find some family lawyer in Bennington County, and he actually ended up in Brattleboro to try to seek a family lawyer. So I wondered how pervasive the problem is. And part of the reason for my question is we have all these giving loan forgiveness and other things for nurses, which is great, and other professions, teachers, et cetera, et cetera. And then yesterday in appropriations, I mentioned lawyers and everybody laughed, you know. But really, if there's a shortage of a certain part, maybe we should be treating that as well. So encouraging them to be in Vermont.
Well, it's
I said, I certainly know when I've supported a couple of families who were going through the family court system that it was pretty hard to find them a lawyer, particularly a lawyer that will work with lower income families. And we know with domestic violence, that can be such a huge impact on someone's income.
the challenge comes in two ways. One, to find volunteers who are willing and able to take these cases, and the other end is finding the grants and resources to fund legal services to take these cases. Vermont Legal Aid and Legal Services or Vermont are limited in their grants and which cases we can take. So we're often stuck not being able to take as many cases as we might like. And these are the main resources that would provide any loan forgiveness. Entering into a public service legal career would provide limited loan forgiveness if somebody was interested in that, but then we're further limited by the funding sources. There just aren't a lot of resources that would allow us to tackle family law cases.
Well, just a thought, I don't know if it'll have any luck in this year's appropriations bill, but it's something to keep in mind as we move forward. I thank you very much. Are there any other questions? Laura? Laura, thank you very much. Our next witness is Sarah Robbins in the room with us.
Thank you. Good morning.
Morning, Sarah.
For the record, Sarah Robinson, Deputy Director at the Vermont Network Against Domestic and Sexual Violence. Just happens to be our lucky day, and it is our annual member organization advocacy day. We haven't had one of those since before the pandemic, so we're very lucky to have some advocates from several of our member organizations in the room, as well as actually a family law attorney that works with us at the network, Attorney Poth, who, as Attorney Byerly, represents victims of domestic violence pro bono as part of the legal clinic that's part of the network. I'm so happy to have these folks in the room with us today. But thank you very much for taking up this bill and for the invitation to speak about H45. You had an opportunity last week to hear about the experience of abusive litigation from two survivors, but I wanted to emphasize what Attorney Byerly says, that while domestic violence is most often equated with physical violence, survivors and their advocates have long known that there are many forms of intimate partner abuse. And that when an abusive partner engages in litigation abuse, they're seeking to exert control over their partner by filing repeated legal motions against or involving a survivor. And in its most basic form, this abusive litigation is a misuse of court proceedings by abusers to control, harass, intimidate, coerce, and impoverish survivors. And not only does this cause significant long-term harm to survivors, it is also an abject waste of public resources and diminishes trust in the court system. Litigation abuse can take many different forms. And as Attorney Byerly highlighted, often abusive partners use the family court system, especially legal motions related to divorce and custody, to exert this coercion, control, and continued contact with survivors. Abusive partners will bring repeated motions, often with no factual or legal basis, seek to relitigate matters that have previously been settled by the court, or seek to bring legal motions in various jurisdictions after receiving unfavorable rulings. In addition, abusive partners also will bring civil lawsuits against survivors or those that support them in an effort to isolate their former partners or bring actions against the support system that is supporting survivors. And not only do these filings necessitate ongoing contact between an abusive partner and a survivor, they're also financially devastating. Frequently, abusive partners will represent themselves pro se in these legal matters. And because of the stakes, especially around child custody, survivors almost always need access to legal representation at a significant financial cost, and need to take time off from work and away from home to respond to these legal motions. So H45 provides a pathway for survivors to address this abusive litigation without extreme legal risk. This approach draws on successful statutory frameworks that have been implemented in both Washington and Tennessee, and have been proposed in Massachusetts, New York, and Rhode Island. I was actually just speaking with my colleagues in Massachusetts and Rhode Island last week, and they're in the same kind of place we are here in Vermont, and are very hopeful that laws will be in effect in those states by the end of their legislative sessions. Through establishing a process to obtain a civil order against abusive litigation, survivors and the courts will have additional tools to address this abuse while protecting the due process of those using abusive tactics. This legal tool will allow the court to screen legal filings, protecting both the well-being of the survivor and the resources of the court. H45 also includes several safeguards to ensure that this proposed statute isn't used against survivors of domestic violence. This includes a two-part eligibility test, which first establishes that a plaintiff has been a victim of domestic violence and that their former partner has used litigation tactics. And if enacted, we view this as a critical step, but truly just one component to address abusive litigation in the courts. And it will require a comprehensive approach, including judicial training and support for survivors seeking such orders. I'm very interested and agree with all of the conversation that has happened so far about the lack of especially pro bono and low bono family law attorneys in Vermont for survivors to access in these cases. And I just wanted to respond to a few things that were raised in testimony last week as you were discussing the draft. The first was a question about the evidentiary standard for these orders, which is the preponderance of the evidence. And I did submit to Peggy a chart that we have developed. It should be posted shortly, if not already, on your webpage. And we do believe that preponderance of the evidence is the appropriate standard. It is the standard for most civil orders already, for relief from abuse orders, for sexual assault and stalking orders. And so we strongly believe that that's the appropriate evidentiary standard. And I also wanted to address one other question that came up when you were discussing the bill last week, which is about the eligibility for victims of domestic violence. So a court, and I'll actually go to the revised version of the bill that was just posted, so I can give you an accurate page citation. All right, so on page,
Sarah, using the amendment.
I'm using the amendment
Just
that
so
was
that-
posted.
okay, I just wasn't sure.
Page
that
what?
everybody-
On page 2, so you'll see a list of criteria that a court essentially, when they're determining whether a person is eligible to seek an order against abusive litigation, they first have to determine that that individual has been a victim of domestic violence. And so on page 2, you will see lines 1 through 14 are all of the various eligibility criteria. So the way that we view all of these are simply the first door that survivors need to be able to walk through to make the case to the court that they are eligible to seek such an order. And I just wanted to highlight that other states already actually have less restrictive criteria than what's listed here. And in the bill that came over from the House, for example, in Washington state, an emergency relief from abuse order would make someone eligible. In the proposed bill in front of you, it must be a final order. And so I do think that there was a question about, in particular, item 6 here, a court determination of probable cause for a charge of domestic assault and criminal conditions of release. And Judge Zone spoke to this a bit last week, but essentially there are so many things that are completely out of the control of a survivor when charges have been brought related to domestic violence, including whether a prosecutor decides to move forward with such a charge. So we really feel like keeping the eligibility where it is here in the proposed bill is important. We already feel like it's significantly restrictive, and that this will provide us a good opportunity to understand how many people need to seek these orders. And we think that all of these factors listed, lines 1 through 14 on page 2, ought to remain in the bill. That's it, but I'm happy to answer any questions that you might have.
Senator Walls.
Yeah, so this is more restrictive than many states. Is
Some
it
states, yeah.
too restrictive?
This was the result of a lot of conversations that happened as the bill was both being drafted and in the House, and a lot of conversations that I engaged in with Judge Zone And we feel comfortable with where this is. We feel like this is going to be a good start. And this will provide us an opportunity to understand whether the survivors that need this protection are able to access it using this eligibility. And if not, we'd come back to the legislature and ask for a change.
Great, thank you.
I have a question. I hope you take it in the spirit in which it's
Of course.
asked. I can remember back when I was first elected here, doing the Victims' Bill of Rights. Back in, those of you who are old enough to remember, some of you may not, but it was, I think, 1994 or 5 when we did the Victims' Bill of Rights. And it was a real battle.
Mhm.
Then over the years, we accomplished a lot, I think, in terms of the survivors and victims. But until this year, I never heard, and maybe it's my own ignorance, of abusive litigation. And I'm wondering why it took 30 years to come to this particular place. I mean, I think we've had improvements. We've seen where there's been failures in the system to protect survivors, but I had never heard of abusive litigation, and so I'm curious as to why it took 30 years to get here.
It's a great question, and I appreciate it very much. So I would say that there's kind of two answers to that question. The first is that our understanding of domestic violence has become more complex and nuanced over time, and that's a good thing. That when we look back to the 80s, it wasn't until the early 80s that even all states had criminal statutes related to domestic violence that considered it a criminal matter. And at that point, there has and was a very narrow understanding of domestic violence as purely physical violence. But I think we've come to understand that domestic violence and intimate partner violence is a set of behaviors that can include physical violence, but includes so much more than that. And so I see this as part of that evolution as we're understanding the ways that violence between intimate partners manifests itself. The other thing that I will say is that it has taken us some time, I think, to understand the limitations of Rule 11, which is something that was discussed last week in testimony. And this, court rule that has and does sometimes provide, in the most extreme cases, some court intervention around vexatious or abusive litigation. The way that the case law has developed around that over time, and honestly, the impacts that has on cases and on survivors when they petition a court to consider Rule 11 violations. I think we've just found over time that that's not a sufficient tool to address this kind of behavior. And so I think that this is augmenting that tool, and certainly something that now we've had a few years under our belt, understanding how this has worked in Tennessee and Washington, seen it be successful, but we haven't seen it flood the courts with these kinds of requests. It's really these cases where there's this kind of extreme behavior. So we feel like it's a well-tailored tool and something that will benefit Vermonters.
Thank you very much. That's helpful. Other questions for Sarah? Great, thank you.
Actually,
Go ahead. Sue.
So, as you probably know, fully in support of this bill. I'm just curious if the one thing that I'm curious about is on page 2, section C, which is how a judge would determine if summons and complaint is abusive or harassing or intimidating, and the other standards or the other qualifiers that are used there. What does the judge take into consideration?
I think that'd be a great question for Judge Zone. I will say that, I'm not sure that I can speak specifically to how a judge would determine that. But I will say that as you see the factors listed below in D, that those are examples of the ways that litigation that is abusing, harassing, intimidating, threatening, or maintaining contact, that can be what that looks like. But I think that would be a more appropriate question for the court.
That makes sense. Thank you.
Thank you. Would you, I wonder if the folks here in the room who are working in the field would mind introducing themselves so that we know where you're all from.
Name and organization.
Laura Sokolowski from Safe Line,
Orange County.
Orange County.
Great.
Mary from Mosaic, Washington County.
Garcia from Hope Works, Chittenden County.
Catherine from Hope Works, Chittenden County.
Lynn from Safe Line in Chelsea, and we serve Orange and Northern Windsor.
Orange and Northern Windsor. Okay.
Tiffany LePage from Pennington County.
And Edward Poff, staff attorney with the Vermont Network.
Jerome, I'm an intern.
Okay, great. Thank you all for being here. I think it's nice to have folks that work in the field and actually have to do the hard work. Not that we don't do hard work and that Michelle isn't the hard work. Michelle Childs is next. From the Office of Legislative Counsel. Peggy, would you note that we should have Judge Zone back to go over this next week,
Yes,
or the next time it's up, but,
that's tomorrow.
well, if he's available. I will ask, I should have, Karen Jacobson is here from Attorney General's office too, if she wants to wait.
Bill, sorry. I know, I see that I got multiple things going on here, sorry.
Aaron, if you want to weigh in, you're welcome to at any point. Morning.
Good morning, Chair Sears. Good morning, Senators. I don't really have anything to add to the testimony from this morning. We continue to strongly support this bill. Did I forget to say Aaron Jacobson from the Attorney General's office?
Yeah.
I believe I did. Yes, for the record, the Attorney General strongly supports this bill. We appreciate the amendments that, from our perspective, just clarify the structure of the bill in response to some concerns that Senator Baruth raised, was that last week. So appreciate those updates, Attorney Childs, and we don't have any questions or concerns. Just appreciate all of the work on the bill and think that it will provide important relief for abuse survivors. And so thank you.
Thank you.
All right, so I'm going to share my screen. We're going to go over, I started an amendment for you. All right, everybody can see that. So I've just made changes to the definitions, and
Right.
I will start off by saying I can't claim credit for it because I think right after we got out of the hearing last time, Judge Zone said, oh, I took a stab at it and he did a great job and I just needed to do a little finessing with the language. This draft hasn't been through editing since I figured we're going to do a little bit of markup this morning, and then I can send it through so you can have a clean copy next time you take a look at it. So starting out looking at the definitions, nothing has changed substantively. It's just a structural change, but I'm going to walk you through. So remember, we're creating a new subchapter in the abuse prevention chapter of Title 15. So definition of abusive litigation. So remember, there's a lot of criteria there and analysis and things you have to check off in terms of being able to qualify as it being considered abusive litigation. So the first one is that the opposing parties have a current or former family or household member relationship. So remember, you have kind of an expansive definition of household member that's currently in the abuse prevention chapter that includes folks who have either had or currently having a dating relationship or a sexual relationship. And so you'd have to have that family or household member relationship, or there's been a civil order or criminal conviction determining that one of the parties has stalked or sexually assaulted the other party. Remember, you have provisions in Title 12 that provide for protection orders for folks who don't fit into the Title 15 definitions of family or household member. You can get a protective order under Title 12.
I'm remembering a woman from the White River area a few years back who was stalked by somebody from New Hampshire. Was constantly in her face, giving her flowers, doing it, and just really abusive. And I remember we did something with that, but that would be the stalking type of case.
If she,
I mean, he was convicted of stalking and all that.
right,
So if he continued litigation against her, that would allow,
correct.
even though they never had a sexual relationship or any kind of other relationship.
Right.
It was just his stalking.
Right, so either if he had a conviction for stalking the
But he
plaintiff.
did after she, I
Right.
remember, I mean, it was just one of those, I don't know if Sarah remembers.
Sounds familiar.
Yeah, I think he was from New Hampshire, actually.
But it wouldn't just have to be a conviction, it could also be a civil order under Title 12.
Right.
So if the person, because you know that oftentimes stalking because of having to navigate around First Amendment issues.
Well, I'm just, the reason I raise it is because we're thinking of mostly of people who had relationships in the past, and not necessarily. So this would cover that kind
Correct.
of case as well.
Yep. So subdivision 1B is that the party who's filing, initiating, advancing, or continuing the litigation has been found by a court to have abused, stalked, or sexually assaulted the other party pursuant to, and then here's the list of things that will qualify under B. And so just like what we were talking about, you have a final order, abuse prevention order. So as Sarah mentioned, this does not include temporary orders, those issues that are issued ex parte and then you have the hearing on the final order afterwards. So this is just the final orders. Senator Booth, we're on page 2 of the amendment.
Thank you.
And so the next one is a final order pursuant to what we were just talking about in Title 12, orders against stalking and sexual assault. Also includes a final form abuse prevention order. Could be an order under the parental rights and responsibilities chapter around conditions of parent-child contact in cases that involve domestic violence. It could be a conviction for domestic assault, stalking, or sexual assault. And then the final one is a court determination of probable cause for a charge of domestic assault, where the court imposed conditions of release pertaining to the safety of the victim. So I know that was one that kind of came up that you perhaps wanted to have some more conversation about.
Question for you.
Mhm.
So I like that it's in there, but I also don't want to accidentally create any contradictions. And so I'm looking at that, the court determination of probable cause, which means that a conviction hasn't happened. But then I'm looking back on the first page in subsection A under abusive litigation. It says household member relationship, or there's been a civil order or criminal conviction determining the following. But it doesn't, I don't see. I mean, so do you see where the potential?
Yeah, I'll take a look at that and
Okay.
see whether or not I can tweak that a little
Okay.
bit. So, but thank you for pointing that out. All right, so moving on to subdivision 1C on line 15, the litigation is being initiated, advanced, or continued primarily for the purpose of abusing, harassing, intimidating, threatening, or maintaining contact with the other party. And so Senator Booth, before you came in, I was talking about, so I have not changed anything substantively in this, but it's just been reworked. I know that at the last hearing, Senator Booth, you brought up the issue about whether or not instead of primarily it should say in whole or in part. I expressed a little concern there around that I think you could be getting into some due process issues because if you say primarily, so it just has to be, you know, a little bit more than half. If you say in whole or in part,
Well, that was just a suggestion.
right, so, but I think if you back away from primarily, I mean, again, it doesn't have to be solely on that basis, right? But if you back away from primarily, I think, you know, when you think about family court things, there's probably a lot of, you know, there could be multiple reasons why somebody might file something. And as Sarah was talking about, and the witness from legal aid, you know, a lot of these filings do pertain to parental rights and responsibilities and modifications for child custody orders, things like that. And parents do have a fundamental constitutional right to care and control of their children. And so I think I would just caution you about backing away from primarily in that circumstance, because if it's in part, it could be that, well, you know, the litigant genuinely wants to maybe see their child more or wants to change the custody schedule because they've got it now that they're working, maybe they're working weekends now instead of during the week or something like that. But there may also be, you know, it may be a combative relationship between the parties, and they, you know, there may be a little bit of vexation there or things like that, but it's not necessarily the primary reason why the litigant is filing it. So I just wanted to raise that for y'all.
Yeah, I mean, it seems as though it will raise the bar, but I hear you saying that it may be proper at the bar.
I think you might just wind up with a lot of litigation. If you backed away from that, I think you might wind up inviting some challenges that perhaps you might prefer to not deal with. And then finally, on subdivision D, at least one of the following applies. The claims, allegations, or legal contentions are not warranted by existing law or reasonable argument for the extension or modification of the law or establishment of a new law. Top of page 3, the allegations and other factual contentions are without adequate evidentiary support or are unlikely to have evidentiary support. And the final one is that an issue or issues that are the basis have basically already been litigated. And so they're just trying to relitigate the same issues over and over. So the only other thing I changed is in the next section, I'll show you in a minute, but I did want to mention Senator Sears. I did look up to double check. So on, you'll see on line 2, we use the existing definition of foreign abuse prevention order that is already used and elsewhere in law, and indeed the U.S. Virgin Islands do qualify under that language where you see on line 15, territory or possession in the United States.
Okay.
So we're already covered there.
If it's a New Hampshire resident.
Right.
Yeah. Okay, good.
And then the only
Could be, I mean, it's hard to believe. It could be any other state or territory.
Correct.
But more likely it's somebody from a border state. Am I correct?
I'm sorry, my computer just decided to restart on its own.
Oh, I'm sorry. They do that, you know?
They do that. It didn't even give me a warning. I don't think I have a battery problem. But you can
At any
still
rate.
do that.
No, really, the question was to make sure that, and I understand now, it'd be any state or territory, but it's more likely to be somebody on the Mass border,
Sure.
New York border,
Right.
New Hampshire border.
Right.
At least in my district, it'd be Mass in New York. And that abused, that survivor would be covered.
Right. So it could be that they have a New Hampshire abuse prevention order, and that would be recognized here, enforced here, and would qualify in terms of.
No, the abuser lives in New Hampshire. In the
Right.
case that I raised, the stalker lived in New Hampshire, was from New Hampshire. And evidently she worked in a, I don't remember all the details, but I think she worked somewhere in Lebanon.
Sorry. I'll just show you since it looks like you guys have hard copies as well, just while my computer is
Yeah.
rebooting. The only other change I made to this was if you take a look at page 4 on section 1182. And I just eliminated the subsection A, which was kind of a reiteration and just we were following the laws and legislation in other states and had modeled it primarily after that. I cut that subsection A out because it's repetitive of the definition. And I just tweaked subsection B to be that a party who meets the requirements of the definition of abusive litigation may request an order restricting abusive litigation in following circumstances. And so those are the only two changes. You know, they're not substantive. It's really just technical and kind of rearranging for readability.
And I wanted to say, I think this opening section on page 1 and page 2 is much easier to understand now.
Great. So I can walk you again through the rest of the bill or answer questions.
Yeah, I got probably 10 or 12 questions, Michelle.
10 or
We'll
12.
try to keep it to 2. After listening to Sarah and looking at, and I'm sure everyone here is totally schooled in how this all transpires, but I'm familiar with TROs and articles and so on and so forth and stalking. How does this order work? What's the process? I mean, is it a temporary order that would based on the preponderance of evidence? Because when you get a temporary, it's a 14-day order, you got to go before a judge. How does this order work?
So this is a restriction on filing future litigation. So it's not going to affect your protection order if you have that.
Right, I realize that.
They're not going to affect your custody or anything like that. But if the survivor in the circumstances files and says, you know, challenges and says, you know, I'm being harassed through these constant filings of litigation, and they request an order from the court restricting the other party from filing abusive litigation, and the court grants that, then that person who is subject to the order, if they want to file any new litigation against the survivor, they're going to have to get permission from the court. And the court is going to be kind of like a gatekeeping there, where the court is going to be able to look at it and say, okay, what is the purpose of this? Is there a legal basis for this? Have these issues been already litigated? Like, is there a, you know, it's just a little bit of it's checks and balances to make sure that that person is not continuing to harass or abuse the survivor through the courts.
So I'm looking at page 5, line 1. And this is what brought on my question, obviously. So once the order is given on the preponderance of evidence, so the individual filing doesn't have to go back before the court again within like 14 days to actually appear before a judicial officer. It says any court of competent jury may now on its own motion or determine that a hearing is necessary to determine if a party is engaging in abusive litigation. How does that fit in with everything we're talking about here?
So this is just if the court, so if they file the motion and the court can look at what's been filed with regard, and so they could look at it and let's say the survivor files something and says, okay, this new suit that they're filing against me, we've already litigated this, and here's the order from the previous court saying that, you know, no, rejecting these claims, dismissing the suit, or whatever. If the court can make a determination based on the filings, they can do so. But if they feel as though they need to have a hearing and they need to gather more information, then they can set a date for hearing, but it's not required.
Okay, and I don't mean to keep counting on this. Okay. So if an individual files for one of these orders based on the preponderance of evidence, it goes before the judge, doesn't it?
It goes, you file it with the court,
so
correct?
Judicial review.
Oh, yes.
Okay,
Oh,
rather
this is all
a worker
the
coming out and say, yeah, we're going to give you this order, and then you go back into court up to 14 days later to appear before a judge for a final review of this. So that's not the same.
It's not the same as with an ex parte, no.
So
when you know, you'll see on page 4 in section 1182 the circumstances in which the survivor can ask for an order restricting abusive litigation. So it could be that And I'm imagining that in, probably many circumstances, it would be that the survivor would be doing it in response to the abusive party filing new litigation against them. And then when the survivor files their answer in response to that litigation, they may request an order restricting abusive litigation.
So is this done in civil or criminal court?
It is, well, it is going to be, I think primarily it's probably going to be done in civil court, but it does allow any court to do it. So I don't know, I have to think about it, or maybe talk to Judge Zoney about whether or not, I don't know whether or not there would be any no, there wouldn't be, I don't think, any circumstance in criminal court that I can think of.
Because that's was my next, probably final question.
Okay.
You're
Ooh,
welcome.
that's much shorter than 12.
So what's it just says you can't do it no more? There's no fine, no penalty, no nothing? If in fact, the court will just reject anything that's being brought before them as far as.
Yeah, let's go to the language. If you look at page 7 in section 1185, starting on line 12.
Mhm.
So a person who's subject to an order is prohibited from filing, initiating, advancing, continuing litigation for the period of time that the filing restrictions are in effect. However, you'll see in B, if they wish to initiate a new case during the time that order restricting the litigation is in place, then they apply to the court requesting permission essentially to file. And then the court is going to review that to make sure that, because there's already been a finding by the court by issuing the order saying, you have been engaging in abusive litigation. So now you have to basically come and ask our permission to file against the same party again.
Okay, I like
And
that.
then-
So the abuse doesn't continue, in other words,
Right.
judicial review.
Right, so
Great.
they're prohibited from being able to file. And if they do file and, don't go through this process, the survivor can then, like in their answer to that litigation, just attach a copy of that order that was granted and say, this person isn't allowed to file against me without going and getting special permission from the court.
Okay.
So it does,
That's
right.
tremendously.
Right, so it doesn't block them entirely, it just
Right.
says, well, now you need somebody to check your work because you're abusing the system.
Okay, thank you.
Just out of curiosity, would a survivor also be able to use the fact that abusive litigation is being filed against them in a motion to dismiss to strengthen that? And is that a possibility?
In the action that like is currently, let's say you're saying that like if the abuser filed litigation and then the survivor responded
With a motion.
I would say they would file with a motion to dismiss. This has already been litigated, this is whatever, and I request an order restricting the plaintiff from future litigation against me unless they get an okay from the court.
Awesome, thanks.
Any other questions? We're scheduled for S3 walkthrough with Eric at 10. And I think I need to hear from Judge Zoney on this, and I want to take another hard look at the bill before we start to mark up. I think we're already in the markup stage. Michelle's done a great job here.
Okay, so is there anything you want me to do for the next time you take this up? You'll just we'll circle back around?
I think I just want to make, I think the questions that Senator Norris asked and some of the questions I have been answered, but I think I'm concerned about the court process, that we actually are able to do what it says here. Because we have laws against frivolous suits, but it seems like frivolous suits get in and get heard many times. So I don't want to false promise here.
Yeah, and I was just thinking, maybe this stems from Senator Norris's question, but so this process is basically they get an order saying that any new legal motion that they want to file has to go to the court.
Mhm.
And then the court has to do a process, and then they could say, this cannot go forward. And you might have covered this, but is there, let's say that then the abuser just continues to file things with the court.
Mhm.
Do they then have to go through the process each time, or can they say, okay, now with us, you're basically abusing our process?
Right, so
And
the
we're
court issuing sanctions against them for violating the
So that's a
order.
possibility.
So I would, you might want to have Judge Zonay, I will tell you that when, Sarah was talking about in development of this legislation, Sarah and I worked with Judge Zonay, so we were going back and forth with the court. And they were comfortable with this language, but you might want to maybe have him come back in and answer some of these questions about how they how he sees
I
the
think
court
next week we'll have that.
doing that, and talk about what kind of sanctions they might be able to place on someone for a violation of the order.
Quick question, how long would one of these orders last? How long would they be enforced for?
I thought we put in a time period, but maybe that didn't make it. It didn't make it, no, okay, so no, there's no time period on there. So for how long?
Yeah, I think Sarah Robbins, the moment.
Sarah?
So again, Judge Zonay may be able to speak to this, but all orders would have a fixed period. And so different states have approached that differently. But Judge Zonay could speak to what a fixed period might look like. I did want to say on the order is in place and a litigant continuing to bring litigation to the court. The idea is that rather than having hearings on each of those motions, there would be, this bill allows for more of an administrative process, more of a paper review of those motions, to both minimize the waste of the court time and court resources. But the other critically important piece is that a survivor would not have to be part of that process. And so the court would essentially be screening those motions, and every time that a motion is brought, survivor wouldn't have to go to the hearing because the court would be essentially doing that screening. So from our perspective, that's one of the really significant benefits.
But Senator, back to the primarily piece, and I take the point that it's a part of the abuse is to force the survivor into court all the time. But if the survivor doesn't attend the hearing, you have a one-sided presentation about the couple's situation for the children. It seems it's much easier at that point to convince the judge that it's primarily in the right direction without, contestation from the other party. So maybe that's a circle that can't be squared, because otherwise you're just going to have the survivor drawn in each time. But they could make the decision if they wanted to.
Right, and they could also file an answer, in writing.
Yeah.
And then say, if it was something regarding parent-child contact, they could just respond to the complaint in writing in their answer, and then attach a copy of that order and be like, here's my answer, here's the copy of the order restricting abuse, or here, we've already argued about Saturday nights and here's why,
But it's maddening, because I'm remembering the witness and I'm thinking even something like what you just described, she'd have to be paying a lawyer to do those filings for her, because most people are not going to be masters of the filing process.
Right. I mean, that might be something to talk to Judge Zonay about as well. I do think, and I realize I'm an attorney saying this, but I do think that the judiciary does a pretty good job trying to help pro se litigants. That's not by any means to diminish what was being said earlier about there needing to be more legal assistance to low-income people and survivors. But they put a lot of information on their website. My experience and what I've heard is that court clerks are pretty helpful with people with forms you need to file and how you need to do that. And so maybe that's a question for Judge Zonay about what steps can the court take to to ease the burden on survivors and being able to respond to this sort of thing.
Yeah, I already did that.
Yeah.
You know, I also think that
Yeah.
realistically, this is about mitigating harm, right? This is not about, however, there are sanctions that
We'll do
are
that.
included, including attorney's fees,
Mhm.
that if an order is granted, that the order can include conditions that an individual pay the attorney's fees of the opposing party. And so I think that those sorts of things do end up acting as deterrents for that kind of future litigation.
And I think it falls into, you know, with family law, unfortunately, it's impossible to legislate to completely insulate people from abusing the process, in all honesty. And you try to, as Sarah, you try to get as close as you can and mitigate the abuse.
And we're gonna move on to another bill, and we will take up page 45 next week, not tomorrow. But we have basically 3 bills left in here.
I do.
I don't know if it's gonna take up page 40, so I'm not counting that. We do have H 230 that we should vote out next week or the week after.
It'd be great if we could do it next.
And H 288 is the act relating to sale of alcohol beverages in Chittenden County. It seems like that's the only place where there's Killington also.
I just think there's a high density of that kind of stuff in resort
And then we have
areas.
this bill. So those are the 3 bills. And we have the removal of the condom or tampering with the condom, but I haven't scheduled it yet. So that's, and we're gonna try to take next week a look at what the House is doing with some of our bills. Hopefully they're being kind.
I was in there last night.
Pardon?
I was staffing House Judiciary last night. It was weird to be there when they were talking about our bills, you know? I was like, this is strange. Well, you do it all the time.
Just gonna say, welcome to our world.
I was thinking that.
Anyway, these are actual changes to the bill, and I think it's on the notice calendar.
It is.
still.
No, it's on action today.
It's on action. So, you know, the question is, do we accept their changes? Further proposal amendment, or there are 3 choices. Accept the proposal, further proposal amendment, or ask for committee of conference. And obviously, the first choice is always concurrent. So, if possible.
You know, I like everything, but what, curious,
Could Eric walk us through it, please?
yeah, sorry. I didn't know we were doing that. Yeah. I got it.
Good morning, everyone. Eric Fitzpatrick, Office of Legislative Counsel, to talk to the committee about the House passed version of Senate Bill number 3, Act relating to prohibiting paramilitary training camps. As you see from the document in front of you, there's a few changes that the House made in their passed version. The changes are highlighted in yellow. There really aren't a substantial number of them, but let's say I call them 3 different ones. One of them, the first one, substantive, but in some ways clarifying as well. And this is on line 17 of page 1, as well as the exact same one is on line 3 of page 2. And the idea here, you remember that with the paramilitary training bill that passed out of this body in this committee, the prohibition on paramilitary training applied when well, 2 different things, for the teaching and the getting of the training, right? Teaching and the receiving of the training, 2 different prohibitions. With respect to both of them, either the person doing the teaching or the person being taught had to know or reasonably should know that the teaching was going to be unlawfully employed for use in a civil disorder. As the committee talked about it upstairs, I think they came to the conclusion that how would the teacher or even the person being taught actually know that that's what it was going to be used for? It wasn't what was really trying to be targeted here, was that that's what it was intended to be used for. That whether or not they knew that's what they were going to do, they knew that's what they were intending to use it for. So they changed that language to from will be unlawfully employed to is intended to be used in furtherance of a civil disorder. And again, could really view that as a clarification that probably what the committee was intending to get at, but they did that in both places, in the teaching and in the being taught provision over on the top of line 2. So that's change number 1. Change number 2, also on page 1, this was in the being taught. You know, subdivision 1 there is about the teaching, subdivision 2 is about the being taught. And this was actually a suggestion of Professor Mary McCord. You remember the Georgetown professor who you folks had down here as well? She suggested that for the being taught, practicing should also be included. So that's what's being taught not only is training, instructing in the use, but also practicing the use of paramilitary activity. So that's where that one came from. And top of page 2, just the same 2 changes again, the practicing and the intended to be used for rather than will be unlawfully employed. And then the third one is an increase in the fine. You see from 5,000 to 50,000. So there's a policy choice that felt that the penalty should be ramped up a little bit.
Yeah, that was my, I see Tanya had her hand up.
Yeah, I seem to remember, and maybe I am misremembering, that we had a conversation about raising that to 100,000. Did we not actually vote on that?
You might be thinking of S4.
No, because we had testimony that because of the just vast amounts of funds that these organizations have, that 5,000 wouldn't even begin to stop the process. I very clearly remember the conversation. I even thought we voted on it, but apparently
I don't think we ever.
I don't remember how it got to 5,000, frankly.
Well, we were at 1,000. And
Oh,
then
yeah.
there was a suggestion to move it to 5,000, which.
And they're going to 50.
And they're going to 50. I take Tanya's point, but I think 50 is a sufficient bump from where we were. And I guess my sense is these changes are so minimal or acceptable that we should concur. So sending it for another round over there risks that they go back to the bill and find something else. So since we're in line with the big raise they made, I would probably just take it at that.
Yeah, I'm happy to concur. I just, when I saw that change, I was like, wait, didn't we have it at 100? But apparently I just thought we should. And
we did. I know on S4, we did bump it to 50, didn't we?
no, I thought we brought it down on S4.
We brought it down. Originally S4, I believe, was 100,000 for the guns issues.
Okay.
And we dropped it down to, I think, 50.
Yeah, I remember us agreeing on 50. I am spacing on the bringing it down.
And the discussion was these were criminal enterprises in S4, not necessarily. When you think about gangs, I think it just minimizes what these groups really are. I'm okay with the change. I mean, I'm sorry they did a strike call because it makes it look like a bill, but it really isn't much.
Yeah.
And I'm fine with the practice. That's good.
I just got a question of Eric. I don't have a problem with it. I was informed that, I don't know if they have 11 or 12 members in House Judiciary. They got a whole bunch.
Like
11.
Yeah.
11?
Yeah.
I was informed that there was a vote of 8-3 on this.
Yes.
And I don't care who voted what, but there was some concern for constitutionality, which I thought we covered rather well in this committee. The question was specifically asked of you and other members of the room. And I guess that was, did they voice their concerns of the constitutionality in what particular section or?
I think they were not overly specific about what particular constitutional concerns they had. That's true, and that during the vote, that was what was voiced as the concerned about constitutionality. I had explained to them the same explanation that I gave to this committee, and which I think you heard from other witnesses as well, which is that, in my view, longstanding Supreme Court case law takes this out of the Second Amendment. Regulation of militias is done pervasively throughout both the federal and the Vermont constitutions, and it's a separate thing And the Supreme Court has specifically said it's a separate thing. So, again, can't predict with 100% certainty, especially these days, what's going to happen with any statute that implicates firearms. But I do feel like I could say a lot more confidence than any of the other firearm stuff. I think this is probably going to be fine.
Yeah, because I really couldn't see it, and I had one of my constituents reach out to me. I got a call later on because when I don't see your concerns here, but obviously I will certainly reach out and listen to them. I don't have a problem with this,
Well,
but
I think that also the factor that 22 or so other states have similar laws that have been upheld over the years.
Yeah.
Which was what a surprise to me. I had no idea that. And many of them are very conservative states. And so
Right.
I would think that those would have been.
I was interested in where they saw the alleged constitutionality in this.
Senator
My
Lynch.
concern.
Yeah, I was just gonna say, to your constituents' concerns, I would definitely show them the Mary McCord testimony that we got, and maybe she sent something electronically too, but I had some questions at first too, and then after her presentation, I was a lot more comfortable
It's
with.
still on our webpage, I think, somewhere.
Well, and as you well know, I have to be real comfortable. Vice versa, that's no hidden secret, so.
I think I might even have said it.
I think, it's fair to say that in this environment, the gun rights folks feel emboldened by the Supreme Court. And it might just be the sense of, we don't want to give up the argument about constitutionality on any bill that concerns guns, given ruin. But I agree, Mary McCord was completely authoritative about the analogs historically, not even analogs, but very much the same legislation being passed 200 years ago to regulate militias. So
Can you find that document?
Chris Bradley said,
I mean, even Chris said he saw no issue, no constitutional issue in this bill.
you can't get a better,
I mean,
better route than that.
I think too, sometimes people fundamentally don't, like, the Constitution's complex, and sometimes I think that people just miss how it applies and how it doesn't, and just talking through the concerns with them can help them more clearly
Well, I mean, I'll
understand.
definitely reach out to them because, if one person has a concern, I want to hear what it is.
Yeah,
And since nothing's unconstitutional until the Supreme Court rules, it's kind of like your team, the Mets versus the Yankees.
Whatever you like it.
Yeah, you can always say, oh, my team's for sure gonna win because it's in the future. So you can I've had a million discussions with a million.
I've tried to think as we've done bills, what is likely to be overturned? And
Right.
to me, the thing that's most likely is waiting period. I think safe storage is fairly, in the way our version is now, is fairly safe because I don't see that. The extreme risk protection order, I don't see them overturning that. That's
Right.
But I think things like waiting periods, things like stuff that we don't have in our state, but other states have, are likely to come under fire.
Stand a better chance, I guess, of being overturned.
I mean,
Stand a better chance, I guess, of being.
standing a better chance.
I was just curious.
I've tried to
what they
weigh
saw.
things that way, but it's hard you can't predict what they're, I'm predicting right now on the pill, they're gonna go 5-4. I realize we're still live, by the way.
Yeah.
That's my prediction. It'll be 5-4 in favor of keeping the pill.
Hard to say.
After our debate yesterday.
I can, sorry.
oh, no, if we're still on the constitutionality, I don't want to jump in because my question's not related.
Okay.
I'm thinking Kavanaugh and Rogers are not.
It's just that one of the members is from my same district.
Right.
So, and obviously I know him real well, so.
Maybe he
When we
missed.
both go back to Franklin County, I mean, I want to be able to say, what's the story here? Why did you, are we on the same page here? What's going on here? Because I reviewed this and I talked to several people about it. And read it 3 more times and then listened to McCord.
Well, that, I
And
think.
am I missing something here? What did you guys read into this?
Is their notes were.
I did
I missed a lot of things.
I did a floor summary for the House on this bill. I included a little section on constitutionality. I can send that to you, if that would be helpful.
Yeah, I guess so.
Pretty long
Let's look at
paragraph
it.
that talks about.
Yeah.
And the other issue As I recall, it was not just Second Amendment, they were also raising the First
Yeah, you
Amendment
could even-
because of teaching. You know what I mean? You're regulating speech by saying that this can't be taught. So that was the other constitutional issue that we discussed. Again, I think the extremely strong argument then is in First Amendment analysis is what is the state's compelling interest here? And the compelling interest is regulating militias, which is all over both the federal and the Vermont Constitution. So again, I think it's.
So I guess we could argue that out back and forth all day long as a violation of the First Amendment. This, in my personal opinion, this doesn't tell them that they can't do this. We're just telling them that there's certain groups who really don't want to entice to come to Vermont to train you with words.
And, you know, if you speak with somebody and conspire with them to commit a crime.
She
you're
never
not
said
protected by
written
the First
testimony,
Amendment.
Senator, but she did
And that's kind of what this is.
provide
Okay, thank
that.
you.
You're
There's notes
knowingly,
there about what's.
you know, it's going to be intended to be used for civil disorder. So if you have that knowledge, then you're conspiring, basically.
Right, you could have the discussion about paramilitary activity if you weren't planning to, you're intending it that it be used for civil disorder.
So
You
Senator,
were talking about it.
to just wrap this up, Senator Baruch has moved that we report. That we concur with the House proposal on S3. Is there any further discussion? Hearing none, Peggy, would you please call the roll?
Senator Baruch,
Yes.
Senator Norris.
Yes.
Senator Bukowski.
Yes.
Senator Rashid.
Yes.
Senator Sears.
Yes, so you will report the committee's decision. Senator,
I'm sorry?
will you report the
I will.
committee's decision?
Thank you.
Your first bill of the year.
Yeah.
The biennium,
Yeah. Well,
proudly posted on your website.
no, I don't post anything on it.
Peggy will take a break until I think it's 10:30 is our next. You've got my.
10:45.
10:40.